Hello friends, welcome to UPSC Logics, and in this chapter we shall have a look at the directive principles of state policy, which are enshrined in Part 4 of the Constitution and constitute from Article 36 to 51. The framers of the Constitution borrowed this idea from the Irish Constitution of 1937, which had copied it from the Spanish Constitution. Dr. B.R. Ambedkar described these principles as novel features of the Indian Constitution. The directive principles, along with fundamental rights, contain the philosophy of the Constitution and is the soul of the Constitution. Granville Austin has described the directive principles and the fundamental rights as the conscience of the Constitution. So friends, let us have a look at the directive principles of state policy. So let us have a look at the introduction, and these are contained in Part 4 of the Constitution, which constitute from Articles 36 to 51. And the idea of the directive principles was borrowed from the Irish Constitution of 1937, and they had again copied it from the Spanish Constitution. Dr. B.R. Ambedkar called these as novel features of the Constitution. So this question often comes that who called the directive principles as novel features of the Constitution? So it was Dr. B.R. Ambedkar. Then the directive principles along with the fundamental rights have been called the conscience of the Constitution by Granville Austin. So again this question often comes that who has called directive principles as conscience of the Constitution. So it was called the same by Granville Austin, so don't get confused over there. Ambedkar called them as novel features of the Constitution, while Granville Austin called them as the conscience of the Constitution. Let us have a look at the features of directive principles of state policy. The phrase directive principles of state policy denotes the ideals that the state should keep in mind while formulating policies and enacting laws. According to Article 36, the term state in Part 4 has the same meaning as Part 3 dealing in fundamental rights, which means it includes the legislative and executive organs of the central and state government, all the local authorities, and all the other public authorities in the country. Number 2. These resemble the instrument of instructions as told in the Government of India Act 1935. So what were the instruments of instructions? These were the instructions that were given to the Governor General and to the governors of the colonies of India by the British government under the Government of India Act of 1935. And what are directive principles? It is just another name for the instrument of instructions. And the only difference is that these are the instructions that are given to the legislature and the executive to formulate their policies upon. So as you can see, the instrument of instructions were the instructions given to the governor generals and governors of the colonies by the British government, and in the Indian subcontext, directive principles of state policy are the instructions that have been given to the legislature and the executive to formulate their policies upon. The directive principles form a very comprehensive economic, social, and political program for the modern democratic state. So the idea is to realize a high ideal of justice, liberty, equality, and fraternity as outlined in the preamble of the Constitution, and they embody a concept of a welfare state and not a police state, and they seek to establish economic and social democracy in the country. The directive principles are non-justifiable in nature, which means they are not legally enforceable by the courts for their violation, and therefore the government, central, state, or local cannot be compelled to implement them. Nevertheless, the Constitution in Article 37 says that these principles are fundamental in governance of the country, and it shall be the duty of the state to apply these principles in making the law. So these are, as I said before, instruments of instructions that are given to the legislative and the executive to formulate or base their laws upon. These are non-justifiable in nature, which means they cannot be implemented by the court of law, or the court of law cannot force the government to implement them. However, the government, while formulating their policies, has to keep in mind these particular features while making the laws. The directive principles, although non-justifiable in nature, help the court of law in determining the constitutional validity of the law. So, although they are non-justifiable in nature, they have helped the courts in examining and determining the constitutional validity of a law. And the Supreme Court has ruled many a times that in determining the constitutional validity of a law, if the court finds that the law in question seeks to give effect to a directive principles, it may save such a law from unconstitutionality, even though this particular law may be unreasonable in relation to Article 14, which is equality before law, or the six articles, which are Article 19, or the six freedoms that have been stated in Article 19. So, if a particular law which is in conflict with any of the fundamental rights that have been said in Article 14 and Article 19, and yet they conform with the directive principles of state policy, such a law may be held valid by the Supreme Court of India. So let us have a look at the classification of directive principles. Number one is Article 36, and it gives us the definition of the state. According to this article, the term state in Part 4 has the same meaning as in Part 3 dealing with fundamental rights, and therefore includes the legislative and the executive organs of the central and the state government, all the local authorities and all the public authorities. Article 37, it tells us about the application of the principles contained in this part. It means that these principles are fundamental in the governance of the country and shall be the duty of the state to apply these principles in making laws. The Constitution does not contain any classification of directive principles. However, on the basis of their content and direction, they have been divided into three broad categories, which are socialist principles, then they are Gandhian, and then they are liberal intellectual. So socialist principles are generally from Article 38 to Article 47. However, Article 40, 43, 43b, 46 and 47 are contained in the Gandhian principles, and while 44 and 45 are part of the liberal intellectual principles. So the socialist principles are basically the principles that reflect the ideology of socialism, and they lay down the framework of a democratic socialist state which aims at providing a social and economic justice and sets path towards a welfare state. So let us have a look at all the articles, which are Article 38 to Article 47 and are a part of the socialist principles. So Article 38 tells us to promote the welfare of people by securing a social order permeated by justice, social, economic and political, and to minimize inequalities in income, status, facilities and opportunities. Article 39 tells us to secure A. The right to adequate means of livelihood. B. The equitable distribution of material resources of the community for the common good. C. Prevention of concentration of wealth and means of production. D. Equal pay for equal work for both men and women. So if we have a look at this particular point in Article 39, which is point number D, and if we have a look at Article 23, it says right to work and equal pay for equal work. So this particular socialist principles has been put into place. Then E is preservation of health and strength of workers and children against forcible abuse. Then F is opportunities of healthy development of children. So now this is a very basic thing which says opportunities for healthy development of children. And there are a number of constitutional and legal rights that have been given to children. And right to education is one of them for children, Article 21A. Then Article 39A says to promote equal justice and provide legal aid to the poor. Article 41 is to secure the right of work, to education, and to public assistance in cases of unemployment, old age, sickness, and disablement. Article 42 tells us to make just and humane conditions for work and maternity relief. So, as we all know, that a law has been passed in regards to maternity relief, and there's a particular video that I've made on this particular point as well, this particular passing of the law on maternity relief, so please check that. Article 43 tells us to secure a living wage, a decent standard of life, and social and cultural opportunities to all the workers. Article 43A says to take steps to secure the participation of the workers in the management of industries. Article 47 is to raise the level of nutrition and standards of living of the people and to improve public health. So if we have a look at this particular article, Article 47, and we look at the midday meals which have been given in schools, in government schools. So this is one of those particular programs which have been conforming to Article 47, which says to raise the level of nutrition, and we have a lot of examples that conform to the socialist principles, the various government schemes that conform to these particular principles. Now let us have a look at the Gandhian principles, and these principles are based on the Gandhian ideology, and they represent the program of reconstruction that Gandhiji during the national movement had envisioned. So in order to fulfill dreams of Gandhiji, some of his ideas are included in the directive principles, and these are basically from Article 40 to 48, and let us have a look at them. So Article 40 states to organize village panchayats and endow them with necessary powers and authority to enable them to function as units of self-governance. So there's already village panchayats that are in place. Then Article 43 says to promote cottage industries on an individual or cooperative basis in rural areas. This is also in place. Then Article 43B says to promote voluntary formation, autonomous functioning, democratic control, and professional management of cooperative societies. This is also in place. Article 46 says to promote the educational and economic interest of scheduled castes, scheduled tribes, and other weaker sections of society and to protect them from social injustice and exploitation. So as we all know that there are a lot of rights that have been given to scheduled caste and scheduled tribes, and they have been given various number of constitutional rights and various number of articles, like for example Article 17 where untouchability was abolished and its practice in any form is forbidden. Then traffic in human beings and forced labor are prohibited, which is Article 23. Then similarly they have got a lot of educational economic rights, and then again they have got political rights, administrative rights, legal rights. So there are a number of laws which safeguard the interest of scheduled caste and scheduled tribes. Then Article 47 says to prohibit the consumption of intoxicating drinks and drugs which are injurious to health. So we all know that Gujarat is already a dry state. Similarly, Bihar was also made into a dry state not very long time ago. Then Article 48 is to prohibit the slaughter of cows, calves and other milch and draught cattle to improve their breeds. So slaughter of cows is more or less prohibited all across India, barring a few states. The principles included in this category represent the ideology of liberalism. So these are the liberal intellectual ideas, and let's have a look at them. So Article 44, and this is a very important article which has always been asked in a lot of examinations, and this states to secure all its citizens a uniform civil code throughout the country. Then Article 45 says to provide early childhood care and education for all the children until they complete the age of 6 years. Article 48 says to organize agriculture and animal husbandry on modern and scientific lines. Article 48A states to protect and improve the environment and to safeguard the forest and wildlife. Article 49 says to protect the monuments, places of objects of artistic and historical interest which are declared of national importance. So this is also one of the fundamental duties. Then Article 50 says to separate the judiciary from the executive in the public services of the state. And this is basically so that the judiciary is not forced by the executive in judgment. Then Article 51 is to promote international peace and security and maintain just and honorable relations between nations, to foster respect for international law and treaty obligations, and to encourage settlement of international disputes by arbitration. So as we all know that Pak-occupied Kashmir is one of those disputes that is with Pakistan, and we are trying to sort it by arbitration in the International Court of Law. The 42nd Amendment Act of 1976 added 4 new directive principles to the original list. So let us have a look at these particular amendments that came into being by the 42nd Amendment Act 1976. Then by the 44th Amendment Act of 1978, Article 38 was added, and 86th Amendment Act 2002, Article 45, and then 97th Amendment Act of 2011, Article 43B was added. So let us have a look at all of them. So Article 39, 39A and 43A, 48A were added through the 42nd Amendment Act of 1976. And Article 39 states to secure the opportunities for healthy development of children. Article 39A says to promote equal justice and to provide free legal aid to the poor. Then Article 43A is to take steps to ensure the participation of workers in the management of industries. Article 48A was to protect and improve the environment and to safeguard forest and wildlife. Then the 44th Amendment Act 1978 added Article 38, and this was added to the Socialist Principles. So this was to minimize inequalities in income status, facilities and opportunities. Then the 86th Amendment Act of 2002 added to the Liberal Intellectual Principles, and this was Article 45, which made elementary education a fundamental right under Article 21A, as I told you before. Then the 97th Amendment Act of 2011 added Article 43B to the Gandhian Principles, which was a part of the Gandhian Principles, and it added a new directive principles in regard to cooperative societies, requiring the states to promote voluntary formation, autonomous functioning, democratic control, and professional management of the cooperative societies. So all these articles were added at a later on stage through various amendments of the Constitution, and they have been included keeping in mind the development and the welfare of the poor, for example, providing free legal aid to the poor. So B.N. Rao, the constitutional advisor of the Constituent Assembly, recommended that the rights of an individual should be divided into two categories: justifiable and non-justifiable. And this was accepted by the drafting committee. And consequently, the fundamental rights which are justifiable in nature were incorporated in Part 3, and directive principles that are non-justifiable in nature were incorporated in Part 4 of the Constitution. And though the directive principles are non-justifiable, the Constitution in Article 37 makes it clear that these principles are fundamental in the governance of the country, and it shall be the duty of the state to apply these principles in making law. And therefore they impose a moral obligation on the state authorities for their application. But the real force behind them is political, and that is public opinion. And as observed by Aladi Krishnaswamy Iyer, no ministry responsible to the people can afford light-heartedly to ignore the provisions in Part 4 of the Constitution, which means that no ministry can really afford to not take into consideration these fundamental, directive principles while making laws for the country. And similarly, Dr. B.R. Ambedkar also said in the Constituent Assembly that a government which rests on popular vote can hardly ignore the directive principles while shaping its policy. And if any government ignores them, it will certainly have to answer for that before the electorate at the election time. So the framers of the Constitution made the directive principles non-justifiable and legally non-enforceable because of mainly three reasons. And these were: the country did not have enough financial resources to implement them at that particular point of time. Then the vast diversity of the country would stand in the way of their implementation, and the newly born Indian state with its many preoccupations might be crushed under the burden unless it was free and decide the order, the time and place and mode of fulfilling them. So the constitution makers, therefore, taking a pragmatic view, refrained from giving teeth to these principles, and they believed more in an awakened public opinion rather than in court procedures as the ultimate sanction for the fulfillment of these principles. So there has been criticism of the directive principles, and they have been criticized by some members of the Constituent Assembly as well as other constitutional and political experts on the following grounds. So number one is no legal force. So the directive principles have been said to have no legal force, and these have been mainly the reason for which they have been criticized because of their non-justifiable character. And Katie Shah dubbed them as superfluous and compared them with a check on a bank payable only when the resources of the bank permit. And Nasruddin contended that these principles are no better than the New Year resolutions, which are to be broken on the 2nd of January. And even as T.T. Krishnamachari described the directives as a veritable dustbin of sentiments, Casey Ware called them as a manifesto of aims and aspirations and opined that they serve as mere moral homily, and Sir Ivor Jennings thought they are only as pious aspirations. So there are a lot of members of the Constituent Assembly thought that since they were non-justifiable in character, they were just superfluous and were like a check that could not be cashed on the bank counter. Then the second criticism has been that they have been illogically arranged, and a lot of critics opine that the directives are not arranged in a logical manner based on a consistent philosophy. According to N. Srinivasan, the directives are neither properly classified nor logically arranged. The declaration mixes up relatively unimportant issues with the most vital economic and social questions. It combines rather incongruously the modern with the old, and provisions suggested by the reason and science with provisions based purely on sentiment and prejudice. Sir Ivor Jennings too pointed out that these principles have no consistent philosophy. So one of the other criticisms was that they have been illogically arranged. Some of the most important parts have been arranged with superfluous and non-important points. The number three criticism is that they have been conservative in nature, and according to Sir Ivor Jennings, the directives are based on the political philosophy of the 19th century England. He remarked, "The ghost of Sidney Webb and Beatrice Webb stalk through the pages of the text. Part 4 of the Constitution expresses Fabian socialism without the socialism." He opined that the directives are deemed to be suitable in India in the middle of the 20th century. The question whether they are suitable for the 21st century cannot be answered, but it is quite probable that they will be entirely outmoded. So, Sir Ivor Jennings was one of the person who pointed out that these were very conservative in nature, and although they might suit Indian needs at the time of independence, but if they were to be implemented in the 21st century, how logical it would be to implement them. And as we can see that since India is on this path to modernism, so directive principles such as prohibition of slaughter of cows, calves, or organization of village panchayats, etc. These have somewhat held India back. Then the next criticism was of constitutional conflict. And K. Santhanam has pointed out that the directives lead to a constitutional conflict between the center and the states, between the president and the prime minister, and between the governor and the chief minister. According to him, the center can give directions to the state with regards to implementation of these principles, and in case of non-compliance can dismiss the state government. Similarly, when the prime minister gets a bill which violates the directive principles passed by the parliament, the president may reject the bill on the grounds that these principles are fundamental to the governance of the country and hence the ministry has no right to ignore them. Thus, excuse me, the same constitutional conflict may occur between the governor and chief minister of the state levels. So, the directive principles have been criticized on these grounds as well, and are said to have caused a constitutional conflict amongst the various state and center, then president and the prime minister, governor and the chief minister. So these are hypothetical situations where it is said that directive principles can cause these conflicts. So these are the criticisms of directive principles. Despite all the criticisms and shortcomings, the directive principles are not an unnecessary part of the Constitution. And the Constitution itself declares that they are fundamental to the governance of the country. According to L.M. Singhvi, an eminent jurist and diplomat, he says, the directives are the life-giving provisions of the Constitution and they constitute the stuff of the Constitution and its philosophy of social justice. M.C. Chagla, former Chief Justice of India, is of the opinion that if all these principles are fully carried out, our country would indeed be a heaven on earth. India would then not only be democratic in the political sense, but also a welfare state looking after the welfare of its citizens. Dr. B.R. Ambedkar has pointed out that the directives have a great value because they lay down that the goal of the Indian polity is economic democracy as distinguished from political democracy. Granville Austin opined that directive principles are aimed at furthering the goals of the social revolution or to foster this revolution by establishing the conditions necessary for its achievement. Sir B.N. Rao, the constitutional advisor of the Constituent Assembly, stated that the directive principles are intended as moral precepts for the authorities of the state. They at least have an educative value. So let us have a look at the utility and what is the utility of the directive principles. So they act as instruments of instruction or general recommendations addressed to all the authorities in the Indian Union, and they remind them of the basic principles of the new social and economic order and at which the constitution was aimed at building. So that is number first utility of the directive principles. Then secondly, they have served as guidelines for the courts. So they have been serving as useful beacon lights to the courts, and they have helped the courts in exercising their power of judicial review, that is the power to determine the constitutional validity of law, of a particular law that has been passed, whether it is constitutionally valid based on the directive principles. Then number 3, they form a dominating background to all the state actions. and whether it is legislative or executive, and they are also a guide to the courts in some respects. Then they amplify the preamble, and which solemnly resolves to secure to all citizens of India justice, liberty, equality, and fraternity. The directive principles also play the following six roles. So they facilitate stability and continuity in the domestic and foreign policies, and this they do in respect to the political, economic, and social spheres, and in spite of the changes in the party that is in power. The number two is they are supplementary to the fundamental rights of the citizens, and they are intended to fill the vacuum in part 3 by providing social and economic rights. Number 3 is their implementation creates a favorable atmosphere for fulfillment of fundamental rights. So what it does is that they give an atmosphere for a full and proper enjoyment of the fundamental rights by the citizens. And political democracy without economic democracy has no meanings. Number 4 is they enable opposition to exercise influence and control over the operations of the government. And the opposition can blame the ruling party on the grounds that its activities are opposed to the directive. So that is one of the role which they play. They give an idea to the opposition whether the policy or the law that is being passed by a current government is valid, and they can judge it on based on the directive principles. Then number 5 is they serve as a crucial test for performance of the government. So the people can examine the policies and programs of the government in the light of the constitutional declarations, and people can actually check for themselves how much the government has worked in implementing the directive principles or making laws which are in conformation with the directive principles. Then number 6 is they serve as a common political manifesto. So a ruling party, irrespective of its political ideology, has to recognize the fact that these principles are intended to be its guide, philosopher, and friend in its legislative and executive matters. So these are the roles which the directive principles play. Now there has always been a conflict between fundamental rights and directive principles of state policy. And since the fundamental rights are justifiable in nature and directive principles are non-justifiable in nature, it becomes a moral obligation of the state to implement directive principles according to Article 37. On the other hand, this has led to a conflict between the fundamental rights and the directive principles since the commencement of the Constitution. So, the first time it happened was in the Champakam Duran Ranjan case in 1951. And in this particular case, the Supreme Court ruled that in case of any conflict between fundamental rights and directive principles, it was the fundamental rights that would be held, that would prevail basically. And it declared that the directive principles had to conform and run in accordance or as a subsidiary to the fundamental rights. But it also said that fundamental rights could be amended by the Parliament by enacting the Constitutional Amendment Acts. And the Parliament took this particular case and they made amendments to the Constitution in the form of the First Amendment Act, then the Fourth Amendment Act of 1955, and the 17th Amendment Act of 1964 to implement some of the directives or introduce some of the directives. And this situation became completely changed in the Golaknath case in 1967. And in this case, the Supreme Court ruled that the Parliament cannot take away or abridge any of the fundamental rights. So they said that the fundamental rights were basically sacrosanct in nature and they could not be amended by implementation of the directive principles or amended for the implementation of the directive principles. So the government reacted to Supreme Court's judgment in the Golaknath case, and they came out with two of the amendments. The first amendment was the 24th Amendment Act of 1971, and the second was the 25th Amendment Act. So the 24th Amendment Act was that the Parliament had the power to take away any of the fundamental rights by making an amendment to the Constitution. And they introduced the 25th Amendment Act, which inserted a new article, which was Article 31C. And basically, it inserted two new provisions that no law which seeks to implement the socialistic directive principles that were specified in Article 39B and C would be void if they were in contravention with the fundamental rights that were under Article 14, 19, or Article 31. And the second point was that no law containing a declaration for giving effect to such policy shall be questioned in any court on the grounds that it does not give effect to such a policy. So what the government did was basically first it said that any of these amendments were, if they were in contradiction with Articles 14, 19, or Article 31, they would be still valid. And second was that they could not be challenged in the court of law. So that was what 25th Amendment Act of 1971 did. And then came the Keshwanandan Bharti case of 1973. And in this particular case, what the Supreme Court declared was that the second provision of the Article 31C as unconstitutional and invalid on the grounds that judicial review is the basic feature of the Constitution and hence cannot be taken away. However, the above first provision of Article 31C was held to be constitutional and valid. So Keshwanandan Bharti case was basically about the 25th Amendment Act and the two provisions which were inserted into the Constitution by the 25th Amendment Act. So the first provision was held valid, which was like if any of the laws that were based on directive principles and were not in conformation with Articles 14, 19, or Article 31, this particular point was held valid. And the second point, that no law containing a declaration for giving effect to such policy shall be questioned. So this particular point was held to be unconstitutional since judicial review is supposed to be the basic feature of the Constitution and hence cannot be taken away. So friends, I hope this is clear. And then came the Minerva Mill case of 1980. So what happened in the Minerva Mill case was that in 1976, the 42nd Amendment Act extended the scope of the first provision of Article 31C by including within its protection any law to implement any of the directive principles and not merely those specified in Article 39B and C. So what the government did was, via the 42nd Amendment Act, it extended the whole scenario of the Article 31C, the first part of Article 31C, and said that it did not merely, the directive principles did not merely extend to those specified in Article 39B and C. So what it did was like it accorded a position of legal primacy and supremacy to the directive principles over the fundamental rights conferred by Articles 14, 19, and 31. So this particular extension was declared as unconstitutional and invalid by the Supreme Court in 1980. What it means is that the directive principles were once again made subordinate to the fundamental rights. But the fundamental rights conferred by Article 14 and 19 were accepted as subordinate to directive principles specified in Articles 39b and c. Further, Articles 31, right to property, was abolished by the 44th Amendment Act, 1978. So in the Minerva Mill case, the Supreme Court held that the Indian Constitution is founded on the bedrock of the balance between the fundamental rights and the directive principles. They together constitute the core of commitment to social revolution. They are like two wheels of a chariot, one no less than the other, and to give absolute primacy to one over the other is to disturb the harmony of the Constitution. So the current position of the fundamental rights is that it enjoys the supremacy over the directive principles, and yet it does not mean that the directive principles cannot be implemented. The Parliament can amend the fundamental rights for implementing the directive principles so long that the amendment does not damage or destroy the basic structure of the Constitution. So friends, I hope you have understood this. So let us have a look at the distinction between the fundamental rights and directive principles of state policy. Fundamental rights are negative in nature as they prohibit the state from doing certain things, and directive principles are positive in nature. Fundamental rights are justifiable in nature and are legally enforceable in the court of law. Directive principles are non-justifiable in nature. These have legal sanctions. Directive principles are moral and political sanctions. Fundamental rights promote welfare of the individual and hence they are personal and individualistic. Directive principles, on the other hand, promote a welfare of the community, hence they are societarian and socialistic. Fundamental rights do not require any legislation for their implementation and they are automatically enforced. Directive principles require a legislation for their implementation. Fundamental rights In the case of fundamental rights, the courts are bound to declare a law violative of any fundamental rights as unconstitutional and invalid. And in case of directive principles, the court cannot declare a law void of any of the directive principles as unconstitutional and invalid. As a matter of fact, they can uphold a law on the basis of it implementing a directive principle. And fundamental rights aim at establishing political democracy in the country, while directive principles aim at establishing social and economic democracy in the country. So friends, this was all about the directive principles of state policy, and I hope you have understood what directive principles of state policy is. So thank you so much for watching, and do like and subscribe to this channel if you have enjoyed this video, and have a nice day.